The third line on, that glass board is going to send your client straight to federal prison. The words broke out at 1:45 in the morning. Arthur Vance, the lead litigation partner, froze mid-sentence, his marker hovering in the air. The 45th floor boardroom of Vance and Partners fell dead silent. Arthur turned around, glaring with pure venom at the person who had spoken, Maya Jenkins, a night shift janitor standing beside her trash cart. "What did you just say?" Arthur grit his teeth. "Who gave you permission to speak?" "The liability waiver in line 3. Maya pointed at the massive glass whiteboard. "You're applying Section 102B7 of Delaware law, but the ruling in Reinvestors Bancorp invalidated it when a board approves its own compensation knowing the company is insolvent. If the plaintiffs use Section 220 to demand internal records, your $3.2 billion defense will collapse in 10 minutes. A young associate quietly checked Westlaw on his tablet, turned pale, and gave Arthur a subtle nod. Billionaire Richard Sterling stood up, holding his drink as he walked over to Maya with a sneer. A night shift janitor teaching New York's most expensive lawyer how to try a case? "Where'd you learn the law? Out of mop bucket?" "I taught myself," Maya replied calmly. "And that doesn't make your argument any less wrong." Arthur's face turned beet red. He slammed a dry erase marker onto the floor in front of her. "Take off those gloves and prove it then, trash." He quickly scribbled a complex reverse merger and asset stripping scheme on the second board. Sterling pulled out a bank check and slapped it on the table. "I'll bet $5 million. Tonight, if you can prove Arthur's strategy is garbage. But if you're wrong by even a single comma, I'll have you locked up for trespassing, and your little brother will be living on the street." Maya bent down and picked up the marker. "Deal." Nobody in that room knew who Maya Jenkins really was. To them, she was just a nameless shadow arriving at midnight to clean up their trash. People looked right through her like a gray wall. But life had pushed Maya into dark corners no one in that room could ever imagine. 8 years ago, her mother, a canning factory worker, was diagnosed with late-stage cancer. The pharmaceutical company owned by Richard Sterling used fine print loopholes in her insurance policy to deny coverage. Her mother died on a gurney in a public hospital hallway, leaving behind massive medical debt, and her 7-year-old brother, Leo. Maya dropped out of college at 19. She worked 3 jobs at once, washing dishes in the morning, making deliveries in the afternoon, and cleaning office buildings at night. But every night, after tucking her brother into bed in their cramped Bronx apartment, Maya sat at a broken kitchen table. Under the weak flicker of a bare bulb, she opened a cracked phone to watch free open lectures from Yale and Harvard Law. She borrowed hundreds of books from the Brooklyn Public Library, Federal Civil Procedure, Advanced Corporate Law, Supreme Court Case Law. She took notes in cheap notebooks, and when she ran out of money for paper, she wrote over old newspapers in black ink. She didn't study for a degree. She studied out of anger. She wanted to understand the legal system that men like Sterling and Vance used to crush people like her mother. She memorized every precedent, statute, and loophole like a veteran memorizing a minefield. And tonight, those men had walked right into hers. Maya walked up to the glass board. She didn't take off her cleaning uniform. Her mop remained leaned against the wall nearby. "Mr. Sterling," Maya said, strangely calm, "you might want to get your pen ready to sign that check. Because your $1,800 an hour lawyer strategy isn't just wrong. It's a death sentence for your company." Maya pressed the marker to the glass. The soft squeak of dry ink echoed through the silent room. "Let's start with the reverse merger structure on board 1, Maya said, drawing a red circle around Arthur's diagram. "Mr. Vance advised you to transfer $500 million in intellectual property to a shell company in the Cayman Islands, then lease it back as convertible bonds. He calls this a protective loan." Maya turned to look at Arthur, her gaze sharp as a blade. But Mr. Vance forgot the updated Uniform Voidable Transactions Act in New York. When a company facing major litigation transfers assets without receiving equivalent value, that is automatically considered actual fraud. Arthur turned pale. That's a legitimate commercial transaction. Legitimate. Maya smirked. She kept writing. In 2019, the Second Circuit Court of Appeals ruled in Tribune Company. Fraudulent conveyance litigation that shell company structures are void if their sole purpose is hiding assets before trial. Plaintiffs don't need to prove intent. They just need to show the loan lacked market interest rates. She turned to the junior associates. Did any of you check the interest rate on the Cayman loan? It's 0.5%. What's the Federal Reserve's prime rate right now? Over 5%. A tenfold difference. That's undeniable proof of asset stripping. A young lawyer bit his lip, staring down at the table, unable to look up. Richard Sterling spun around to face Arthur, his voice shaking with anger. Arthur, is that true? Don't listen to her. Arthur sweated bullets, his tie pulled crooked. She's just a janitor picking up buzzwords online. Our overall structure is still safe. Safe. Maya stepped over to the second glass board without slowing down. She was like a conductor leading a complex symphony where every note was a law. Let's talk about class action certification under Rule 23b3, Maya continued. Mr. Vance assured Mr. Sterling that the plaintiffs couldn't form a class action because they come from 12 different states with different consumer laws. He told you that predominance doesn't exist. Maya wrote 4 large words. Barrington v. Sterling Pharmaceuticals. 4 years ago, your own company was sued in the Federal District Court of Southern Illinois. In that case, the court applied the fraud on the market theory. When you release false financial statements nationwide, it impacts all investors the exact same way, regardless of what state they live in. Rule 23 is completely satisfied. Maya turned around and tapped the end of her marker against Arthur Vance's chest. Mr. Vance didn't miss this out of incompetence. He ignored it on purpose, because if he admitted the class action would be certified, you'd have to settle immediately, and his firm would lose tens of millions of dollars in ongoing litigation fees. You're lying, Arthur screamed, lunging forward to snatch the marker back. Stand still, Richard Sterling roared. The billionaire stepped closer to the board, his eyes glued to every case law Maya had written. As a ruthless businessman, Sterling didn't know every statute, but he understood numbers and risk perfectly. Sterling turned to Arthur, his voice cold as ice. Arthur, is she right or wrong? Answer me now. Arthur stammered, his lips trembling. We have a backup plan. Your backup plan? Maya interrupted. Is it the mandatory arbitration clause on page 45? Without looking at the 500-page binder on the table, she recited it from memory. Chapter 14, Section C. All disputes shall be resolved through confidential arbitration in Delaware. But Mr. Vance forgot that Congress passed the Ending Forced Arbitration Act, and more importantly, the Supreme Court expanded that principle in Morgan v. Sundance. If you've already participated in court litigation during trial prep for over 6 months, you automatically face a waiver of arbitration rights. Maya drew a massive red X across Arthur Vance's entire diagram. Your strategy isn't worth a dime. Tomorrow morning, plaintiff lawyers will use these exact loopholes to freeze your personal assets. You won't just lose $2 billion. You'll be stripped of your CEO title before noon. Room 45 sank into heavy silence. The junior lawyers knew they were watching an intellectual slaughter. A night janitor with no degree was single-handedly destroying the reputation of Manhattan's top law firm. But Arthur Vance couldn't accept being beaten by a cleaner. Julian, Arthur turned to his assistant, eyes bloodshot. Pull up draft 4 on the secure server, the one we updated at 11 tonight. A giant LED screen lit up, displaying digital legal documents. Arthur sneered, his face full of desperation. You're good at memorizing old books, trash. But this is an unreleased internal edit. How do you explain Section 18A, which was just added based on the Digital Revisions Act? Arthur winked at Julian. Julian quickly typed a command. On the screen, paragraphs shifted and section numbers swapped places right in front of Maya to confuse her and make her fail. Maya looked up at the screen. Her hand froze. The legal logic she had built in her mind collided with the tampered information. Arthur stepped closer with a triumphant smirk. What's wrong? Out of tricks? You're just garbage that got lucky. You lose. Get out of here and prepare for prison. Maya closed her eyes. In the quiet darkness behind her eyelids, she didn't see the LED screen. She saw cold winter nights in the Bronx. She saw the dim light at her small kitchen table. She saw every page of law books she had read, until they tore, every case she had analyzed 100 times. Her knowledge wasn't based on memorizing text line by line. She understood the DNA structure of the law. When Maya opened her eyes, the panic was completely gone. You edited Section 18A at 1:52 a.m., Maya said, terrifyingly calm. You deliberately changed controlling shareholder to indirect related party to bypass Section 144 of Delaware law. Without looking back at the screen, she kept writing on the third glass board. But this sloppy edit creates a direct conflict with Section 6. 2 on page 12, which you forgot to fix. Under the rule of contra profrontum, when a contract has a contradiction created on purpose by the drafter, the court will automatically interpret it in the way most favorable to the injured party, the plaintiffs. Maya wrote continuously at incredible speed. She didn't just fix the fake text. She rebuilt the entire original logic, exposing their exact document tampering right in the room. You just handed them proof of spoliation of evidence, Maya said, placing the final period on the board. If the plaintiffs find out you edited this document during trial prep, the judge will issue a default judgment against you, without even opening a trial. My God, a young lawyer whispered, covering his face. Arthur Vance stumbled backward, tripped over a leather chair, and collapsed onto the floor. His expensive tie choked at his neck as he gasped for air. Suddenly, a static crackle came from the conference speakerphone on the table, followed by a deep, powerful voice. Arthur, hang up the phone and leave the room. Everyone froze. It was the voice of Thomas Vance, the 80-year-old founder of Vance & Partners, a living legend and former U.S. Attorney General listening in privately from Florida. Mr. Vance. Arthur scrambled up, shaking like a guilty child. This is just a misunderstanding. Shut up, Arthur, the former Attorney General's voice cut through the air like a blade. I've listened to every single word for the past hour. I spent 50 years building this firm's reputation, and in one night you turned it into a pile of fraudulent trash in front of a night shift janitor. The speakerphone fell quiet for a few seconds before Thomas Vance spoke again, this time to Maya. Young lady, what is your name? Maya Jenkins, she answered, her voice steady. Ms. Jenkins, Thomas Vance sighed. Your analysis of Section 102(b)(7) and Rule 23 was a masterpiece. In 40 years of practice, I have never seen a young lawyer with such sharp legal instincts. Where did you graduate from? I never went to law school, Mr. Vance, Maya replied. I learned from the Brooklyn Public Library and open lectures online. 10 seconds of silence filled the phone line, a legend bowing to an unknown genius. Arthur Vance, Thomas Vance said coldly. You're fired. Effective immediately. Leadership of the litigation team is transferred to our D.C. branch. Report to the Bar Association Ethics Committee tomorrow morning. No, Mr. Vance. Please. Arthur begged, but the phone line cut off. Richard Sterling stood frozen. The billionaire looked at his disgraced lead lawyer on the floor, then turned to look at the glass boards covered in Maya's red handwriting. Sterling walked over to the table, with trembling hands, picked up his Montblanc pen, and pulled the bank check closer. He filled in the amount, $5,000,000,000. Sterling signed his name at the bottom and tore the check from the book. He walked over to Maya and handed it to him with both hands. His arrogance from earlier was completely gone, replaced by deep fear and respect. I promised, Sterling said raspy. This check is yours, Ms. Jenkins, and I'm sorry for what I said earlier. Maya looked at the $5 million check, the money that could change her life, pay off all debt, buy a house for her brother Leo, and secure their future forever. She took the check. She didn't tear it up. She folded it into quarters and slipped it calmly into the pocket of her gray janitor jacket. This money isn't your charity, Mr. Sterling. Maya looked the billionaire straight in the eye. This is my legal consulting fee for the past hour. And if you want your company to survive tomorrow, tell your new team to follow what I wrote on that board. Maya walked to the corner, picked up her mop and bucket, and pushed her cleaning cart out of room 4501. The automatic glass doors closed behind her, leaving behind Arthur Vance weeping on the floor and junior associates frantically taking pictures of her board notes like a life-saving scripture. She changed out of her uniform in the basement locker room and put her old jacket back on. When she walked out of the Manhattan skyscraper, dawn was breaking. The night rain had stopped, giving way to the first rays of sunlight reflecting off New York City's glass towers. At the bus stop across the street, her 15-year-old brother, Leo, was waiting on a wooden bench, holding 2 warm bagels in his hands. Maya, Leo ran over, holding out a bagel. Are you done with your shift? Are you tired? Maya looked at her brother and smiled, her brightest, freest smile in 8 long years. She took his hand and placed the $5 million check into Leo's small palm. Let's go, Leo, Maya said softly in the fresh morning air. We don't have to work night shifts anymore. 3 months later, Maya Jenkins appeared on the front cover of the Yale Law Journal. She received a full scholarship to Harvard Law School, funded by Thomas Vance himself. The $2 billion lawsuit against Sterling Capital settled successfully based entirely on the framework Maya wrote on, that glassboard, saving thousands of working-class families' pension funds. In her new office at Harvard, beside rows of expensive law books, Maya still keeps her old mop and her 70-cent notebook from the Brooklyn Library. I tell you this story because it reflects a harsh, yet powerful truth of modern life. Every day, we pass by thousands of people in gray uniforms, cleaners, delivery workers, security guards, servers. Society teaches us to judge them by their jobs, to measure their worth by their income, and to assume that status equals intelligence. But genius, brilliance, and greatness don't care about bloodlines or expensive suits. Never judge a person by the clothes they wear or the job they do to survive. Because beneath that worn-out uniform might be a mind capable of shattering the most arrogant fortresses in the world.